Nevada's approach to rent increases has evolved significantly in recent years, as the state has grappled with rapid population growth, a tight housing market, and intense political debate around affordability. If you manage rental property in Nevada, the rules are more detailed than you might expect, and they continue to change. The governing law is found in Nevada Revised Statutes Chapter 118A, the Residential Landlord and Tenant Act, along with recent legislative amendments that have added new requirements. Nevada does not have traditional rent control that caps the dollar amount or percentage of a rent increase. A landlord can technically raise the rent by any amount. However, what Nevada does regulate, and has been regulating more aggressively in recent legislative sessions, is the process, the notice period, and the circumstances under which increases can be implemented. The most important procedural requirement is the notice period. Nevada requires landlords to provide at least 60 days written notice before a rent increase takes effect for month-to-month tenancies. Under NRS 118A.300, the landlord must deliver written notice at least 60 days before the increase becomes effective. So, if rent is due on the 1st and you want the increase to take effect on June 1st, you need to deliver the notice by April 1st at the latest. 60 days is longer than the 30-day standard used by most states and gives Nevada tenants meaningful time to evaluate the increase, adjust their budgets, or begin looking for alternative housing. The extended notice period reflects the Nevada legislature's recognition that the state's rapid rent growth has created challenges for tenants who need time to plan. The notice must be in writing and must clearly state the amount of the current rent, the amount of the new rent, and the date the increase takes effect. The notice must be served by one of the methods authorized by the statute: personal delivery, leaving a copy with a person of suitable age at the tenant's residence and mailing a copy, or sending by both regular and certified mail. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing midterm increases. At renewal, the landlord must provide the 60-day notice of any proposed increase. This means the landlord needs to make pricing decisions and deliver the notice well before the renewal date, at least 60 days before the new rent would take effect. For week-to-week tenancies, Nevada requires at least 30 days' notice before a rent increase, which is notably longer than the 7-day standard most states use for weekly tenancies. This extended notice period for weekly tenants reflects the same legislative philosophy of giving tenants adequate time to plan. Now, here's where Nevada has been getting more active: local regulations. Several Nevada jurisdictions have enacted or considered additional restrictions on rent increases that go beyond state law. The City of Las Vegas, North Las Vegas, Henderson, and Reno have all been involved in tenant protection discussions. Nevada does not currently have a statewide preemption statute that prevents local governments from enacting rent regulations, which means municipalities have the legal room to adopt their own rules. Some jurisdictions have explored rent caps, additional notice requirements, or relocation assistance provisions. The Nevada legislature has also considered, and in some sessions past, bills that would impose additional requirements on rent increases statewide. Recent legislative sessions have seen proposals for rent caps tied to the CPI, longer notice periods, and enhanced disclosure requirements. While not all proposals have become law, the trend in Nevada is clearly toward more regulation, and landlords should stay informed about both state and local legislative developments. Rent increases cannot be retaliatory. Nevada has a strong anti-retaliation provision under NRS 118A.510 that prohibits landlords from raising rent in retaliation for a tenant exercising any right under the Residential Landlord and Tenant Act. Protected activities include making a good faith complaint about habitability to the landlord or a government agency, filing a complaint about a code violation, exercising any right under the Landlord-Tenant Act, and participating in a tenants organization. Nevada's anti-retaliation statute provides that if a landlord takes adverse action, including a rent increase, Within a specified period after the tenant's protected activity, there is a presumption of retaliation. The landlord must then demonstrate that the increase was motivated by legitimate business factors, market conditions, operating cost changes, or property improvements, rather than by the tenant's complaint. The consequences of a retaliatory rent increase in Nevada are significant. The tenant can recover actual damages or up to the amount specified in the statute, plus attorney's fees. A finding of retaliation can also invalidate the increase and undermine the landlord's credibility in any related proceedings. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Nevada Fair Housing Law, found in NRS Chapter 118, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity or expression, disability, familial status, or ancestry. Nevada's anti-discrimination protections are broader than the Federal Fair Housing Act. The inclusion of sexual orientation, gender identity or expression, and ancestry provides additional categories of protection. The Nevada Equal Rights Commission investigates fair housing complaints and can take enforcement action. A discriminatory rent increase, one that targets tenants based on any protected characteristic, can result in significant liability, including damages, civil penalties, and attorney's fees. Nevada also has specific provisions regarding how rent increases interact with the manufactured home community market. Under NRS Chapter 118B, tenants in manufactured home parks have additional protections regarding rent increases, including specific notice requirements and limitations. If you own or manage a manufactured home community in Nevada, you must follow the Chapter 118B requirements rather than the general residential landlord-tenant provisions. From a practical standpoint, Nevada's rental market is heavily concentrated in the Las Vegas metropolitan area, which includes Las Vegas, Henderson, North Las Vegas, and surrounding Clark County communities. The Las Vegas metro accounts for approximately 75% of the state's population and an even larger share of its rental housing. Understanding the Las Vegas market is essential for most Nevada landlords. Las Vegas experienced one of the most dramatic rent surges in the country during the recent growth period. The combination of population influx, driven by Californians and others relocating for lower taxes and more affordable housing, limited new construction during the post-2008 recovery period, and strong job growth created conditions for rapid rent appreciation. Rents in some Las Vegas neighborhoods increased by 20 to 30% in a single year during the peak growth period. This explosive growth generated intense political pressure for rent regulation. The Nevada legislature responded with enhanced notice requirements and ongoing debate about additional protections. While no rent cap has been enacted at the state level, the political momentum toward additional regulation remains strong. The Las Vegas Strip and the tourism industry that drives it create unique rental market dynamics. The hospitality, entertainment, and service industries employ a large portion of the valley's workforce, and these workers' housing needs drive demand across the metro area. When tourism is strong, employment is high, and rental demand is robust. During downturns, such as the severe contraction during the 2008 recession and the pandemic, the rental market can soften dramatically. Henderson, Las Vegas's largest suburb, has attracted families and professionals seeking a more suburban lifestyle while maintaining access to the metro area's employment centers. The rental market in Henderson has been strong, with rents generally higher than in central Las Vegas. North Las Vegas has seen significant growth and investment, including the arrival of major employers. The rental market there has improved from its historical reputation as a more affordable alternative, and rents have increased accordingly. Reno, Nevada's second-largest metro area, has experienced its own growth boom driven by the technology sector, warehousing, and distribution, including Tesla's Gigafactory and numerous data centers, and lifestyle migration. Reno's rental market has tightened significantly, and rents have increased substantially. The Reno-Sparks metro area offers a different market dynamic than Las Vegas, smaller, more tech-focused, and with a distinct seasonal tourism component related to Lake Tahoe and skiing. Carson City, the state capital, has a smaller, more stable rental market driven by state government employment. Rents are more moderate than in Las Vegas or Reno, and increases tend to be conservative. Rural Nevada, including communities like Elko, Winnemucca, and Ely, has rental markets influenced by mining, ranching, and specific employers. The mining industry creates cyclical demand in some communities, similar to what we've discussed in other resource-dependent markets. One best practice for Nevada landlords: create an annual pricing calendar that accounts for the 60-day notice requirement. For each unit, identify the date you need to deliver the notice to have the increase take effect at the desired time. Build in a buffer of several extra days for delivery and service. Missing the 60-day deadline means the increase cannot take effect on your planned date, which delays revenue. Another best practice: monitor both state and local legislative activity carefully. Nevada's legislature meets every 2 years in odd-numbered years, and tenant protection bills are regularly introduced. Between sessions, local governments can act independently. The regulatory landscape is evolving, and what's legal this year may change next session. Joining a local landlord or apartment association that tracks legislative developments is a practical way to stay informed. For landlords in the Las Vegas market, be aware that the competitive landscape has shifted in recent years. A significant amount of new apartment construction has come online, adding supply to the market. While demand remains strong, the additional supply has moderated the extreme rent growth that characterized the peak period. Pricing your units competitively relative to both existing and new construction is important for maintaining occupancy. For Nevada landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority, typically the Southern Nevada Regional Housing Authority in the Las Vegas area or the Reno Housing Authority in the Reno market. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance of the desired effective date. Nevada requires landlords to return the security deposit within 30 days of the tenant vacating. Nevada does not allow landlords to charge non-refundable deposits. Any deposit intended to cover damages must be refundable. The only amounts that can be designated as non-refundable are specific fees like cleaning fees, which must be clearly labeled in the lease. These rules don't directly regulate rent increases, but landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. For the complete guide to Nevada rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.